There are primarily two options for seeking trademark registrations overseas. Number 1. Filing a trademark application in each country or region where you want the trademark registered. The cost of filing an application directly varies from country to country, as does the way applications are processed, although there are general similarities. Number 2. Filing an international trademark application under an agreement called the Madrid Protocol. The Madrid Protocol allows you to file a single application and designate by ticking a box any one or more of the 105 member countries in which to seek protection. The office through which you filed your application will then send the application to the World Intellectual Property Organization, which in turn transmits the application to the trademark office in each country that you designated. Each office will then examine the application for compliance with the local laws, and if the application passes, the mark will then be protected. Once your application has passed the necessary requirements, the Madrid Protocol registration will be enforceable as if it were filed separately in that country. Using the Madrid Protocol generally results in a cost saving compared with filing separate national trademark applications. If protection is to be sought in a large number of countries, the savings can be significant. Before filing overseas trademark applications, you may want to consider any translation or pronunciation difficulties with the trademark, and if necessary, consider an alternative name in some countries to have greater appeal to consumers there. It is also worth searching the national trademark databases in any overseas countries of interest before filing an application to check that your chosen mark is available to use and register in that country. Under the terms of an international convention called the Paris Convention, which most countries are party to, you can file a first application to register a trademark in one country, say in the UK for example, and allow up to 6 months before applying to protect the trademark outside the UK, whilst maintaining priority to protect your trademark over any third-party conflicting trademark applications which have been filed since your initial trademark application. You can still file applications after the 6-month period, but they will not enjoy this priority.